to record. Okay. I guess it's time we should start with the session. Good evening, first of all, to everyone present here. I would like to begin by addressing the audience first, on behalf of the whole Viraam family. Today, we have all gathered here for an extensive and exclusive session brought to you by Viraam on abortion regulation and chilling from extremists. To join us on this remarkable session, we are thrilled to have invited a truly exceptional guest who has contributed immensely in the field of law. Our guest today, Professor Guha Krishnamurthi, is a celebrated educator in the field of law, with his extensive career ranging from being an associate professor in the University of Oklahoma College of Law, assistant professor at South Texas College of Law, Houston. Among his influential expertise being an educator, he has also served as an officer of court as staff attorney in Supreme Court of California, United States District Court for Northern District of Illinois, and U.S. Court of Appeals for the Seventh Circuit. His work in the field is certainly praiseworthy, recognized along with his very extensive knowledge and expertise on several diverse subjects, such as the case for the abolition of criminal confessions and caste discrimination, and many more. His research paper on pluralism and anti-discrimination is truly enlightening. I would encourage all the young audience to read on to them. To define his work in such a short span of time would be an injustice to the expertise and the dedication he put into. To sum up, I would like to welcome Professor Guha Krishnamurthi to share his insights and knowledge with us throughout this extensive session. Without any further ado, I would like to invite Professor Guha to take over. Thank you, sir.
Oh, thank you so much for that generous introduction. So I just want to say a little bit about this paper, Abortion Regulation and Chilling from Extremists, kind of where it comes from. So obviously in the United States, we have a big sea change in our reproductive rights policy that came a few years ago in the case called Dobbs. And Dobbs essentially overturned prior cases in American law that allowed for actually quite a robust reproductive rights regime, in particular, including abortion rights.
Right.
Essentially, for the first, trimester, women could freely get an abortion. They would have pretty good access, unfettered access to abortion. And in the second and third trimesters, that can become further limited. That framework has essentially stayed the same. There were some changes to it in the way, in the language, but Dobbs changed all that. Dobbs said, states, we have a federated system. States are no longer obligated to preserve the right to an abortion, even in the first trimester and the like. As soon as Dobbs came down, there were a number of states, and in our federated system, those states usually are either conservative or liberal. It was essentially exclusively conservative states, but many of them that passed abortion bans. And those bans were largely categorical bans. For example, Texas, where I've spent a significant amount of time, had a ban with no exception for rape and incest. It only had an exception for life-threatening injuries. Then Georgia had a ban that had an exception for rape and incest, that one could obtain an abortion in such circumstances, and also had the life-threatening injury exception. Okay, well, what happened after the passage of these bans? Well, what we have seen is a dreadful number of cases where women seeking abortion health care, right, have been denied. And I want to talk about two cases. One of them is the case of a woman named Kate Cox. She lived in Texas. I say this because I think it will be important for just a small point. She's white. She's she's not poor. She's, I don't know how wealthy is, but she has access to resources. She became pregnant, um, and the fetus was diagnosed with trisomy 18, which is a horrible diagnosis that is, an almost always fatal condition for the fetus. What we would generally say is a unviable pregnancy. Kate Cox sought an abortion, but realized that this would become contentious. So she filed a suit to seek that abortion care. And the trial court said, yes, you can get the abortion care. Now, one of the most extreme politicians in the United States, lawyers really, Ken Paxton, who is the Attorney General of Texas, opposed that. He appealed, and he appealed it all the way to the Supreme Court of Texas. And at that time, it became too late for Kate Cox to get a safe abortion. So she left the state, obtained abortion health care, and she came back to Texas. The suit continued, and the Texas Supreme Court said, trisomy 18 is not a good enough reason in order to obtain abortion care. This is, medically laughable, a really terrible judgment. So let me give you now another case which has a much, has a fatal consequence, just extremely horrible. That's the case of Amber Thurman. She lived in Georgia. She became pregnant. She sought an abortion. Georgia had a ban, so she could not get an abortion. So she drove to North Carolina, where you could obtain abortion. And so she drove up there. She was not able to, get a DNC, a certain type of procedure. And instead, she got a medical abortion. So she took some pills according to a regimen, and she came back to Georgia. She has to work, and she had kids, so she had to continue her life. And in that time, she started to have some complications. And these complications became more serious. She sought care, which would essentially require a DNC, that is an abortion procedure. She sought that in Georgia. There, the hospital, right, continued to a wait and see approach, because they had not yet determined. Georgia, again, has an exception for life-threatening conditions. They did not believe that she was yet in a point where her life was threatened. So they kept waiting. And ultimately, they waited too long. They did conduct the procedure, but by that time, Amber Thurman was on a road to a fatality. She died. Extremely sad case. And there's a medical board that is determining now whether that the medical care was appropriate. But there is no doubt that the reason that the hospital, the doctors waited so long was that they were worried about liability. Now, after hearing these cases, the political discourse in the United States has been, we need to write better statutes. How could we make clearer that abortion, when there's a life-threatening condition, is legitimate, or something like that, right? People have focused on statutory drafting. In this paper, essentially, I want to say that that is a sideshow. It's a distraction. Let me see if I can share very quickly this document. Let me see if I can do this. Essentially, I argue that this here. Okay, so this is my paper, and I want to just show you the statute because I think it might be helpful to see here. So this is the Texas statute. And it says it's a categorical ban except for life-threatening injury. And it says prohibition of abortion does not apply if done by a physician and there's a life-threatening physical condition aggravated by, caused by, or arising from a pregnancy that places the female at risk of death or poses a serious risk of substantial impairment, blah, blah, blah. You know, you can't get very much clearer than that with respect to life-threatening conditions. The text is fine. The problem are the extremists. The problem are people like Attorney General Ken Paxton, who will use whatever statutory language there is to oppose someone getting an abortion. Regardless of how clear this is, we do have to write statutes for all sorts of unforeseen moments, conditions, etc. It's not, there is going to be some level of vagueness, some level of ambiguity about what condition is life-threatening and not. That's why we have doctors, right? Anybody who's ever been concerned with their own health seeks medical care for a particular reason. You can't go, we all know that looking online on Google is not a good way of diagnosing yourself. It's a great way of getting anxiety, right? Similarly here, we cannot have a statute that writes down every condition which would be life-threatening. That is not feasible. We have to use certain kinds of terms, but there is inherently in that law some level of vagueness. And that is what extremists like Ken Paxton, like the prosecutors in Georgia, that is what they will employ to reject abortion. And let me say here, so some people may ask, right? Because the American environment in this respect is quite distinct from the world. Who is trying to oppose an abortion in conditions where someone has trisomy 18, where in conditions where a woman's life is threatened? The answer is quite a few people. It's hard to understand why they think this, because it seems unreasonable. But the Pew study in the United States on abortion suggests that there's up to around 8% of individuals who believe abortion should just categorically be denied. No exceptions, including no exceptions for life-threatening conditions. They just don't think that there should ever be an abortion. Some of this is fantastical thinking. Just have the pregnant woman give birth. It will be fine. God will take care, something like that. So, that might be one of the reasons for opposing abortion and such, but nevertheless, they do. The rest of the paper is a sort of theoretical discussion of how we can understand what's going on here. And I'll just say something about that, but how is that in general, when we think about chilling, we think about chilling. Chilling, this means people deterring themselves, being deterred. liability under that statute. In general, we think of chilling in terms of how the statute would be applied. And we think of, we focus on the statute. What are the statutory exceptions? What's the language of the statute? That's how we think of it. This paper suggests that we have to do something else, which is we also have to consider the legal officials at issue, the extremists at issue. If you know that there is a there's an extremist legal official, then you don't really need to think too much about the statute. You just have to, build that risk in. Oh my gosh, I'm going to be prosecuted. It doesn't matter what the statute actually says because I have these extremist officials. And so, in a law and economics type style, I try and separate out the factor of extremism. I suggest that this applies everywhere. So, and my conclusion is in the United States, we really cannot we cannot regulate abortion in the ways that we might think we could, like Texas and Georgia have tried. The reason is because the legal extremists will turn those nuanced bans, which allow for life-threatening conditions, etc., allow for abortions in life-threatening conditions. They turn them into categorical bans. That's what extremist officials do. Now, why is this distinct from other contexts? Because as I observe, chilling by extremists happens in the First Amendment context, happens everywhere. The problem is the chilling cost. The chilling cost here is the risk that pregnant women who are seeking care for life-threatening conditions will die. And that cost is extremely high compared to what people are seeking to accomplish. And as a result, I think that's the reason we really cannot regulate here. Thank you. I'll leave it there.
Okay. Thank you so much, sir, for your wonderful insight. And maybe proceed with some few questions because
Yeah,
our audience would be very much obliged to you for that. My first question to you would probably be, in the extensive research of your current abortion laws, the consequences you ended up drawing was that either eliminate the extreme or do not regulate. Am I right?
Yeah,
Yes.
that's right.
But the nature of the regulation itself seemed morally governed and overlooking the reproductive justice of its own citizen. So is it the extremist, or does that mean that there is a need for better regulation with right commitments, as explained in your papers?
Absolutely. So one thing to keep in mind here is, so my own politics is that we need the commitment, as you say, to reproductive justice, right? That is what we actually have to have. The problem is that, 27 states and the Supreme Court of the United States disagree. And so this paper is in some sense a non-ideal approach, which is let's accept what conservatives in the United States accept, what the anti-choice so-called pro-life movement accepts. They accept, so they want to ban abortion, but they do accept as core that there is that you have to have an exception for women, for life-threatening conditions of women. And what I want to say is, if you adopt their limited understanding of the commitments, the right commitments, even if you adopt their limited understanding, the chilling cost is egregiously high. And it would be high to them too. It would not be high to these extremists. Of course, they are extremists. But even among the pro-life Texas movement or pro-life Georgia movement, pro-life Oklahoma movement from Oklahoma, even they, the vast majority of those people, would say you have to have an exception for a woman who is undergoing a life-threatening condition. And what I want to say to them is, your statutory regime will not protect those people. Indeed, in Texas, another case, since I started writing, there was another case. This case involved a woman who was a pro-life person. Her whole family was pro-life. She was pro-life. She supported the abortion bans. And she was denied care due to the abortion ban. And she ultimately died. So the suggestion is, you are exactly right. I think you are correct. The actual proper commitments are ones that include robust reproductive justice. We're not in that world, unfortunately, in the United States.
Oh, all right. Thank you so much, sir, for that wonderful insight. Uh, since I read your paper thoroughly and I did my own fair share of research on that, I'd like to come up with the next question, if you allow so.
Please do.
With the current abortion laws in mind, what is the stature of US on pregnancy of minors and adults in sexuality?
Yeah, so there's actually a couple of issues that are involved here. So with adolescent sexuality in general, the big question for us is actually not about pregnancy, but is about trans rights. That's the one that is really occupying our attention right now.
Okay.
Um, so that's just an interesting aside, but I'll get back to the pregnancy point. Currently, many states, not all of them, but many states have the following kind of regime if a minor gets pregnant. If a minor gets pregnant and seeks an abortion, then they usually have to have parental consent. If they are not able to obtain parental consent for whatever reason, then they have there's something called a judicial bypass. So you can go seek care through getting a judge's approval. One issue with that in the United States is that judges, of course, are they're often elected. State court judges are often elected, and so depending on where they are elected, there may be they may be forced into legal extremism, right? So I have seen sort of judicial advertisements of the form that say, nobody, I would never grant a judicial bypass, only in the most extreme cases, things like that. So in many states, it could be very, very difficult to obtain judicial bypass. And so, but in general, we have a parental consent regime for minors. And, that I think in the first instance, it does make sense, of course. Parents have the right to raise their children the way they would like. We have judicial bypass regimes in the cases where things are necessary, but unfortunately, those regimes are pretty uncertain at times.
All right, so considering your paper in mind, since I read the paper and the current US abortion laws, does that also include minors and extramarital pregnancies, adults in sexuality?
Yeah, so all of this applies to all of those conditions. Um, with respect to marriage, an early case in the United States, essentially, it's called Eisenstadt, said essentially the restrictions on contraceptive care. There was a case called Griswold that allowed for contraceptive care and essentially banned states from banning contraception. So free access to contraception. Griswold did so largely on one of the key features was the marital bedroom is sacred. So the courts do not need to interfere in the marital bedroom. If people want to get contraception, that's up to them. Eisenstadt very shortly thereafter said this is not limited to married people. It extends to unmarried people as well. And so as a result, we have, look, anything is subject to change. But for 60, 50, 55 years or so, the United States has essentially lived in a kind of rubric where married and unmarried couples have essentially the same access to any kind of reproductive care. There aren't distinctions based on that. The adolescent, again, they are subject to the bans, right? In the same way. And so, yeah, like there's no exceptions for in the statutes that I've seen. There's not particular exceptions for minors. The one thing is that when someone is a minor, there is potentially a greater medical risk to them. And so that risk becomes heightened. And as a result, they may qualify under the life-threatening exceptions for abortion care because they're at further risk due to their age. But really, in general, right now in the United States, if you need abortion care in one of these banned states, the main thing you have to do is leave. Speaking personally, it is very common for young professionals who work in these states to have a plan of action when they or their spouse are pregnant. And it's, the idea is on reproductive health care, right? So if there's a complication, what do we do? And you have to have a plan. And the plan is, okay, if you live in Oklahoma, as you know, I was working in University of Oklahoma.
Yeah.
We have to have a plan to be able to get out to the nearest state where abortion care is preserved. That in my case is Kansas, in Oklahoma, just one state north of Oklahoma. They have enshrined abortion care in their state constitution. So you have to have kind of planning, which is expensive and difficult,
Yes, very well explained. Thank you, sir, for explaining that. So coming back to the Indian subcontinent, if we're talking about, since Viraam is based in Indian subcontinent, and we are an organization working towards indecent and repulsive moves against crime against India in general. So talking about Indian subcontinent and particularly exclusive to Indian laws, the recent amendment of Medical Termination of Pregnancy Act of 2021 brought a significant change in the abortion laws in India by lengthening the permissible period of aborting for pregnant women from 20 to 24 weeks, hence widening the access to abortion. India's stance towards the abortion seems to be by creating a balance of interest of one's personal liberty as well as the state's interest. Keeping in mind the current abortion laws in US, how do you see the distinction between the commitment of the statutes and the approaches of the two nations?
Yeah, I mean, to me, the Indian approach models very much, and I have to say that I think that India has, in general, on reproductive health care, been a stride ahead from, at least on the legal regimes, I think it's been a stride ahead from the United States. So I don't want to suggest that India was following the Roe regime. They may have independently arrived at it themselves. But one thing I will say is it mirrors the Roe Casey, that was the other case, the Roe Casey regime that really stood for 50 years and did pretty well in lengthening 24 weeks makes good sense. Part of the reason that it makes good sense is oftentimes important milestone determinations at 20 weeks, growth ultrasound, and the like. And that information at 20 weeks will tell you a lot about whether a pregnancy is viable, is properly viable. Now, I'm not a medical expert, right? So happy to hear other thoughts on this. But in my experience and study on this, there are certain kind of triggers that occur at 20, 21, 22 weeks. And so that information is so critical that, you know, you want to give pregnant mothers a chance to obtain that information and then act accordingly if they need to, for their own safety, for their own life, but they're also their own future fertility, which can also become really critical. So I think that that is a really welcome change. I think that that's really important.
Right. That being said, I would also want you to put some light into, since the current abortion laws came into picture, it seems that it's curbing one's personal liberty and right to life and liberty. Since you're no more, they have put restrictions on your reproductive health. So, what's your take on that? Like, how do you see it?
Yeah, it's
How
absolutely
like,
dreadful.
is it justifiable to do that? And how is how's the current senses and people are reacting? How are they reacting to it? I just want to know more thoughts on that.
Yeah, no, it's a great question. I think it's absolutely dreadful. It is a constriction of rights. It's, you know, for many people and many politicians in the United States said, uh, are the next generation, I have a daughter who's 1.5. Um,
Oh,
that it is unique in this following sense. My daughter will have less rights than the generation above, than her mother and then her grandmother, you know. That is pretty rare, that kind of, you know, back pull of rights. It's really terrible. And the sentiment is, you know, strongly pro-choice, pro-reproductive rights. The problem is the politics, and we have certain kinds of undemocratic regimes in our politics that make things extraordinary. State and the Senate wields its own individual power, so it's a very powerful entity. But that means the best example is this: California, which has 40 million people,
right,
has equal representation as Wyoming, which has 600,000 people. And Wyoming is, as you'll
right,
guess it, a very conservative state. California is a very liberal state. So this has been a real problem for us.
right. At last, I guess we must address few questions from the audience itself. Uh, would you be open to that?
Sure, absolutely. I see
Yes.
one in the chat. I don't know if you could explain this case to me. That would be wonderful. I don't know the case off the top of my head, but happy to talk about anything.
Yeah. The one of the questions is related pertaining to a particular case. Also, what's your general view on current abortion laws in India? And let's just stick to that.
Yeah, yeah. And again, I think it's really good. You know, I think the regimes are very good. One issue that we do not deal with in the same numbers in the United States, and we actually do not, I don't think there's been very much sophisticated legal thinking about it, is
Mhm.
the issue of sex selection. Because I
Right,
know that India has some level of regime for combating sex selection, right? Like not providing certain kinds of information to patients
right,
because such information might result in sex selection. You want to stop that. We do not have that. We have thus far not seen significant numbers of sex selection in the United States by use of
mm,
abortion. And so as a result, we really haven't had that issue come up. But I think that India's solution is actually like, you know, pretty forward thinking about this, combating that kind of gender discrimination. I'm sure that there are certain costs, but I think it's probably worth it. And again, this all just goes to say, I think that India has done serious thinking, and has been much more nimble, much more agile in addressing the issues that come out of abortion access than the United States really has. The United States has been content with the Roe-Casey framework, and it hasn't dealt with some of these issues. One thing we are seeing, this is not my area of research, but I know people are thinking about it, is that certain kinds of reproductive treatments like IVF can result in abilities to sex select. And you can choose embryos that are male or female. And so there's some sex selection going on there itself. And so it's very that's a very interesting and obviously a very difficult problem to address, because you want people to be able to have unfettered access to their medical information, but you have this dire issue that you need to address. And I think India, in general, from my understanding of how India has treated many issues on abortion, they've done so with nuance, and they've been able to come up with sort of tailored solutions to the problems. One thing that the United States, like I said, the United States really has been overtaken by by a sort of political wing that has really shut down the ability to do many of those things.
Okay. Thank you so much, sir, for that wonderful insight of yours. As we're close to wrapping up the session, I'd like to conclude and by expressing our heartfelt gratitude from the whole Viraam family to you for joining this wonderful discussion. Your work has truly been inspiring to most of us, and I'm sure all the legal professions, all the young lawyers would be looking up to you, looking up to your work. Thank you so much for joining again. And I would also like to thank our audience for joining the session, for this wonderful insight. I hope we all have learned something, some takeaways surely from you. Thank you so much, sir. Please do visit India once.
Oh, absolutely. We come very regularly. We're from Chennai, so we that's where we are usually. But usually these trips now are just to see all as much family as we can and head back. But also if you're ever in the Washington, D.C. area, please let me know. That's where I'm stationed. This was excellent. Thank you so much for the opportunity, and hope to keep in good touch. Please do reach out to me if I can ever be of service.
Surely, surely, sir. Thank you so much. It's been an honor to host you. Thank you so much.
Thank you.